Hello, beautiful people. Mic check, mic check. How you doing? It's good to see you. It's Thursday, right? Yeah, I think so. It's Thursday, November 13th. It's raining here. Hello, beautiful. But I hope you all are having a good morning, afternoon, or evening, depending on where you are watching in the world. It is lovely to see you. Slap that like button, like the appeals court slapped Tory Lanez, and share this live, like the Department of Corrections shared more prison time with Sean Combs. Yes, yes, they did. How generous of them. So we have a couple housekeeping items, but first we'll just start with all the shout outs. Shout out to all the members and subscribers here. Shout out to all the supporters on the Substacks, on the Patreons, on all the places. Okay, all the places. I see you and I appreciate you. Shout out to the best mod squad on the internet, holding it all the way down. Holding it all the way down. It's a busy day outside on the street. So if you see me doing that, that's what I'm looking at. Ah, oh, good. Finally. I'm so sick and tired of y'all bragging. I have a new thing. I have a new thing. I'm not about to tell you about my Lord and Savior, Jesus Christ. No, that's not what this is. Now, can anybody tell me? Can anybody tell the class what this new sweatshirt actually is? One more time, in case you missed it. Coming soon. Seriously, we really do need a West Coast emoji. We really do need that. West Coast savior. We need you. And you delivered. Yes, you did. You delivered. I just felt like Tupac's prominence in the motion to dismiss needed to be memorialized properly. You know? Yeah, I just felt like, yeah, as the West Coast savior, you know? Yeah. I mean, I want it, but I don't want it because I don't want other people to use it. I want it. I want us to have it here. I don't want just anybody and everybody to use it. You know how they be. Well, it's the accurate one. There stands a ban. Yes, that's what we're here to talk about. We're here to talk about a ban. Mhm. A man who did something that he wasn't supposed to do. Yeah. Yeah, the person on the receiving end of that behavior happened to be a black woman. Yeah. And what did he do rather than take accountability for his harm against that black woman? That black woman? Well, let's see. First, he uh went on a little tour via social media, dragging her, coming up with a whole new narrative of the situation. Then he released a song about her. Yeah. And then he got a whole little gang of degenerate bands together to continue to drag that black woman and try and cause her as much harm as possible to distract from the fact that he did something he wasn't supposed to do. That seems to be a common mode of operandi for men who do things that they're not supposed to do. And then when it's pointed out, you're not supposed to do that. What do? They have meltdowns. The histrionics. Ugh. A big old mantrum all over the internet for everybody to see, saying things that are laughable and untrue. But simple minded, non thinking folk don't care about that. No, 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 no. No, 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 no. Because they're misogynistic and don't support black women either. So they just jump on the bandwagon, try and figure out how can they help prop up this BS narrative that basically everybody knows is probably a BS narrative. By any means necessary. Anything but the actual facts. I've seen a lot of mantrums in my day. Yeah, I've seen a lot. If you want evidence that a man is pathetic, behaviors that you find in a mantrum, those are the indicators that a man is actually pathetic. If you want to find indicators that a man is being dishonest and manipulative, the behaviors that you find in a mantrum are indicators. Hmm. He seems to be really having a very strong reaction. I wonder why. Okay, so housekeeping. James Comey and Letitia James are in a South Carolina federal court this morning arguing to get Biscuit Head halitosis tossed out of the seat that she doesn't really occupy because she should not have been appointed as a U.S. attorney to begin with. And the judge said, seems to be some portions of the transcript from the grand jury proceedings that are missing. Huh, how fascinating. Okay, so that happened. And then we've got some Necole Key docket updates. It seems to be no shortage of men with challenged hairlines having mantrums because they're insecure little bands. Yeah, they sure are. Shout out to everybody who's watching. Hit the like button. Yes, this is what it comes down to. When you don't behave in such a way that a man prefers, they feel like that's license. That's permission. When you tell a man no, oh my goodness. When you tell man no, mm, 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 mm. The entitlement that they feel to do whatever. And you have to ask yourself, we talk about it all the time. Is this proportional? It doesn't really make sense. It doesn't seem to be proportional, you know? You seem to be a little hysterical. Your emotions are out of control. Hmm, that's so sad. Okay, so we have new entries on both dockets. Okay, so let's start with the Barry White Family Trust versus Rodney O. Okay, so this beautiful docket entry is from the judge. Okay, so the last time we talked about this, the Barry White Trust came onto the docket and said, we have a settlement agreement. And as a result of that, what should happen if everything with the settlement agreement, is signed, but we have reached an agreement and our lawsuit will be withdrawn within 30 days with prejudice as a result of that settlement being finalized. And if we don't submit a motion to dismiss within that time frame, then judge, we would ask for you to calendar a what's it called? Status conference. Um within 60 days of us letting you know that we've reached a tentative agreement. So that was the last thing that we saw, that this long long nightmare for Rodney O, thanks to his actual attorney, is hopefully coming to an end. So, here's what the judge has to say about that. It having been reported to this court that this action has been settled, it is hereby ordered that the above captioned action is discontinued without costs to any party and without prejudice to restoring the action to this court's calendar if the application to restore the action is made by December 12, 2025. If no such application is made by that date, today's dismissal of the action is with prejudice. So basically, what she said was, I'm putting this back on you. This case is discontinued. as of now, this case is over. If this case actually isn't over, you have until the 12th to tell me that you need to get back on my calendar. If you don't tell me by the 12th that you need back on my calendar with this case, December 12th, not November, not yesterday, December 12th. If you don't tell me by December 12th that you need back on my calendar, i.e. the settlement did not get signed, then I assume everything is fine, and this lawsuit is dismissed with prejudice, which means it cannot be refiled. So she said, I'm not holding a date on my calendar for you if you're telling me that you've got a settlement, but I'm leaving space if something goes wrong for you to be able to get back on my calendar. So as of today, this case is over. And by December 12th, we should see either they will file an official we're dismissing it, or they'll let the calendar just run past the 12th, and the court will officially say this case is over. It's dismissed with prejudice. Okay, so now we're going to flip over to Necole Key versus the Barry White Trust, Kendrick, Future, the Barry White Trust attorneys, Sony, Epic, UMG, Your Mama, Steve down the street, and the mailman who delivers every other Tuesday. Okay? So the last time we talked about this, oh boy, oh boy, oh boy. Fireworks. If you don't know, we've had several lives this week about this case. So what had happened was I made a prediction a little while ago when he got an attorney and he withdrew from this case. I said Rodney O is probably going to come back onto this docket in some way, shape, or form because Necole Key is asserting that she owns his music and therefore has standing to go through with this lawsuit. And he is probably going to have to, come back onto the docket in some kind of way as a third party to fight that, or take up separate litigation to fight that. So the last time we talked about this, we looked at he filed a motion to intervene, and it is damning. It is damning. He accuses Necole Key of faking and forging contracts to try and get more of his money. And because he's got a lawyer, it's a very strong filing. And he's filed the motion to intervene for the purposes of being able to file a motion to dismiss. If he's not a party to this lawsuit, but he's central to it. And so he's filed a motion to intervene for the purposes of filing a motion to dismiss. The next day, while we were in a live, the Barry White Trust came onto the docket and they filed their own motion to dismiss, which is the first official response to the lawsuit. None of the parties have filed a response to this lawsuit because their response date was at the beginning of December. I said the 6th. I think it was actually the 5th. But anyway, so they came onto the docket with their own motion to dismiss. They want sanctions against Necole Key, et cetera, et cetera. They also filed a memorandum of law in support of Rodney O's motion to intervene, with a declaration from Rodney O that is different from the declaration that Rodney O submitted with his own motion to intervene. So Rodney O and his attorneys and the Barry White Trust and their attorneys are like this right now. They've clicked up to address a common enemy, Necole Key. They have said she is vexatious. They've called her everything but crazy and a child of God. They want a federal injunction against her to prevent her from being able to file any litigation without it being pre-approved by the court. and we got to see communications. We got to see a bunch of her text messages and conversations between her and Rodney O and her and apparently other people, and they are stunning, absolutely stunning, and recent. They're recent and they're stunning and damning. So there's that too. So the judge, bless her heart, has come on to the docket for this case as well. And it is the same judge that's dealing with both lawsuits. So she says the court assumes familiarity with this action and the related action, the first lawsuit. The relevant procedural history is summarized only in brief, which means I'm not going to spend a whole lot of time recapping this. We all know what's going on here. I'm only going to write as much as is necessary to justify this order. In the other lawsuit, the Barry White Family Trust sued Rodney Oliver and Joe Cooley. They have settled with Joe Cooley for infringement. Necole Key is Oliver's former, judge said former. She says current. Since you won't fight for you, I will. And I don't care if you have canceled our agreement. What did she say? I don't release myself from my duty to you. Unhinged, okay? Unhinged behavior. Shout out to everybody who's watching. Hit the like button. So I haven't read this. This is my first time reading this with y'all. Judge said former rights manager and agent. Well, that's fantastic. That's because she watches, as I said the other night. They all watch. Fans, delusional biscuit heads and hoe cakes. Wave to him, chat. Wave to him.
I study rap battles for a living.
Hello, beautiful. It's good to see you. Okay. Key filed a motion to intervene that was denied in an opinion of April 9. Key continued to prepare pro se filings on behalf of Oliver. An opinion of October 29 described misconduct by Oliver and noted Key's involvement. Recently, in a letter of November 11, the remaining parties in the first lawsuit reported that they have reached a settlement. Key and Oliver filed this action on April 29, the second lawsuit. Oliver filed a notice of voluntary dismissal, that's Rodney O, withdrawing, leaving the lawsuit on September 9, leaving Key as the only remaining plaintiff. Pursuant to an order of September 15, the defendant's deadline to respond to the complaint is currently December 5. I previously said December 6. On November 10, Oliver filed a motion to intervene as a defendant in this action. Attached to that motion is a draft motion to dismiss. Oliver seeks dismissal of this action and argues that Key lacks standing. According to Oliver, a document that Key has relied on to claim that she is entitled to 20% of his earnings is fraudulent, and in any event, Oliver has terminated any agreement he had with Key that may have entitled her to part of his earnings. Oliver also argues that Key has engaged in other misconduct, including by making false statements and leveling improper accusations against other parties in this action. On November 11, the Barry White Family Trust filed a motion to dismiss. Among other arguments for dismissal, that motion also argues that Key lacks standing. These filings raise serious concerns of potential misconduct by Key that may lead to sanctions. Well, these filings raise serious concerns of potential misconduct by Key that may lead to sanctions. That potential misconduct includes Key's possible creation of a fraudulent document to assert standing and her attempt to act as an attorney for Oliver, including in this action, despite the court's explicit admonition in the opinion of April 9 that she may not do so. Oh boy. Oh boy. Oh boy. It is hereby ordered that Necole Key shall, by November 20, file an opposition to Oliver's November 10 motion to intervene, as well as any opposition to the standing arguments in the Barry White Family Trust November 11 motion to dismiss. Any replies shall be filed. So she has to respond both to the motion to intervene and by Rodney O and the motion to dismiss by the Barry White Trust by November 20. Any replies to her response by Rodney O or the Barry White Trust are due November 25. Key's duty to respond to the arguments in the Barry White Family Trust motion to dismiss that do not relate to standing is stayed pending further order. So the only thing she has to respond to is standing with regard to the Barry White Family Trust motion to dismiss. She doesn't have to respond to anything else pending further order. She only has to respond to standing in their motion to dismiss. It is further ordered that the defendant's December 5 deadline for responding to the complaint is stayed pending further order. So here's what that means. Kendrick Lamar, Future, the attorneys as individuals who are being sued, the record labels, your auntie's ex's baby mama's cousin, do not need to file a response to this lawsuit by December 5th, pending further order from the court. So now nobody has to respond. This is the only thing that the judge cares about. Standing has to be established to determine if anybody does need to respond to the lawsuit. So for the sake of judicial efficiency, the judge is saying, you can stop working on that now. You don't need to respond by December 5. Let's deal with standing. And then her little capstone on top. Yeah, her little capstone on top. It is further ordered that Necole Key is hereby advised that evidence of misconduct in this action may lead to sanctions, including Dismissal. Judge said if you put a single fraudulent document on this docket, bands, fans, biscuit heads, and hoe cakes don't seem to understand that no means no. Mhm. Judge said, go ahead. Go ahead. Stand where you stood. Say what you said. Go ahead. Put it in writing. Put it on the docket. What you got to say? Go ahead. Go ahead. What you got to say? I'm sorry, what? What was that? No, let's not forget. We still haven't seen the best filing yet. Remember that? Wait until my next one. It's going to be the best one yet, and they're going to talk about it on the news, and I'm going to be famous. So, yeah, she's got until the 20th. So we'll be talking about this again in the next week. I mean, we already knew she was going to hit the docket. We already knew as the filings were coming in that she is loading ChatGPT just as fast as she can. She's probably got several of them at this point in time. Um, Good God Almighty. So now she's got official direction from the judge. Judge said, "Go ahead." Hmm. And now we arrive at our main event. The Second Appellate District Court in the Court of Appeals of the State of California has ruled on Tory Lanez's much anticipated appeal that everybody said was going to work. Anyway, for those of you who just got here, look what I made. So anyway, this guilty man's very guilty. Hmm. Band, fan, hoe cake, very, very guilty. Hmm. Yeah, very guilty. Hmm. Yep. Guilty of what? Oh, he shot a woman. Yeah, he did. They don't know how anything works. That's why they'll listen to bald-headed bands on the internet. Hmm. It's 46 pages, and I'm gonna probably read just about every single word for all the bands, fans, biscuit heads, and hoe cakes that are watching. Hi, who were insistent to me these past several months. He's an innocent man, and the court made a mistake, and the evidence is missing, and he really took the fall to protect a black woman, and blah 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 blah. Next time you see a bald-headed band talking bad about a black woman, he a band, he a fan, he a band. I changed the lyrics, but I need to get them both in. He a fan, he a band, he a fan, he a band. So, this was filed by the Baez Law Firm and Unite the People and Crystal Morgan. In December 2022, a jury convicted Daystar Peterson of assault with a semi-automatic firearm on Megan Pete, carrying a concealed unregistered firearm in a vehicle and discharging a firearm with gross negligence. The court sentenced Peterson to 10 years in the state prison. On appeal, Peterson contends the trial court committed a number of errors. We find no prejudicial error and, accordingly, affirm Tory Lanez conviction. Of what? Oh, yeah, he shot a woman. Mhm, a black woman. I just wanna say to everybody who's watching, support black women. Buy my shirt. Facts and procedural background. Peterson fires 5 shots at Megan Pete, striking her in the feet. Dance, bitch. Remember that? On July 12, 2020, Pete went to a gathering at Kylie Jenner's house. At some point, Pete texted Peterson and told him to come. When Peterson arrived, it was really late. Eventually, Pete wanted to leave. Pete, her friend, and personal assistant, Kelsey Harris, and Peterson got in an SUV driven by Peterson's driver, Jaquan Smith. An argument started about the relationship among Pete, Harris, and Peterson. Pete asked to be let out of the SUV. Pete got out and started walking away. She heard Peterson say, "Dance, bitch." I'm just going to move this. The appellate court writes in the center of the page. So Pete turned her head a little bit and saw Peterson pointing a gun at her. Yeah. She froze. Pete heard shots. She looked down at her feet and saw all the blood. Pete dropped to the ground and crawled into a driveway. Pete felt pain in both of her feet. After that, it got blurry. Pete saw Peterson and Harris walking toward her. Peterson started apologizing. Pete got back into the SUV. They heard police sirens, and Peterson told Pete and Harris, "Please, y'all, don't say anything. I'm about to sign a big deal. I'll give both of you $1 million each." At 4:27 a.m., Harris sent a text to Justin Edison, who handled Pete's security. The text said, "Help. Tory shot Meg. 911." Police stopped the SUV. They asked everyone to get out. Pete told the police she'd stepped on glass. She didn't tell them she'd been shot. When asked at trial why she told the police she'd stepped on glass, Pete referred to the then recent murder of George Floyd. Pete testified she didn't know if they're going to shoot first and ask questions later, and she didn't feel safe with the police officers. Officers found a 9mm Luger semi-automatic handgun on the floorboard of the front passenger seat. The gun was in the slide lock position, meaning all the rounds had been fired from the magazine. It was warm to the touch, even though it was cold outside at that hour of the morning. Officers also found a bloody towel in the back seat. The officers took Peterson, Harris, and Smith into custody. At the station, officers checked the hands of all three for gunshot residue. The samples taken from Peterson and Harris were positive for gunshot residue. A criminalist testified at trial that if Harris had been standing within feet of an individual firing a firearm and came into contact with that individual after he fired a firearm, she would not be surprised if Harris tested positive for gunshot residue. No gunshot residue particles were detected on the sample taken from Smith. An ambulance took Pete to the hospital. Neither in the ambulance nor at the hospital did Pete tell the medical providers that she'd been shot. She later explained, "In the Black community, it's not really acceptable to be cooperating with police officers." Pete also said that when a woman accuses a man of something, people have a hard time believing you. Hmm. I don't know if you could see it. You probably couldn't, but my eye just started twitching. Could be the banner of this channel. She added, "This whole situation in the industry, like a big boys club, like I'm telling all of y'all's friends, and now everybody about to hate me." Yes, when they link up together and declare you're the Black Joan of Arc. Around 9:05 in the morning of the shooting, Peterson called Harris from jail. A recording of the call was played for the jury. Harris told Peterson that Pete was still in the hospital and she was waiting outside. Peterson said, quote, "I know she probably never ever gonna ever talk to me ever again, but bruh, I just want you to know, bruh, Nigga, I was just so fucking drunk. I never do some shit like that, bruh. Regardless, that's not gonna make anything right, and that's not gonna make my actions right, bro. But I'm just deeply sorry, bruh. So, like, I feel crazy, bruh, but made a mistake. Like, what happened, happened already, bruh. I can't take it back, bruh. I'm just telling y'all, I'm sorry, bruh. Oh my God, these self proclaimed YNs are so pathetic. At 8:59 p.m. that evening, Peterson texted Pete. The text said, Meg, I know you probably never going to talk to me again, but I genuinely want you to know I'm sorry from the bottom of my heart, and I was just too drunk. Nonetheless, shit should have never happened, and I can't change what I did. I just feel horrible because I genuinely just got too drunk. I love you, and I hope you're okay. Shout out to everybody who's watching. Hi, hit the like button, share this live. Peterson sent Pete other text messages just apologizing. Pete had bullet fragments in both of her feet. She had to have surgery and physical therapy. Pete couldn't walk for a while. She can't really feel the left side of her foot. About 4 days after the shooting, Pete told police who had shot her. Pete testified she'd had a change of heart because Peterson had tried to start getting ahead of the story online. He'd put it on a bunch of different narratives about what actually happened. Yes, because that's the only thing that bands have is their online narrative. DNA testing of the Luger revealed a profile of at least 4 people. Peterson could not be excluded or included. His contribution was inconclusive. DNA testing of the magazine also revealed a profile of at least 4 people. Peterson was not one of them. No usable fingerprints were found on the gun or the magazine. In response to the prosecutor's question at trial, Pete testified she was having a really difficult time sitting up there and trying to comfortably tell her story, apparently referring to spectators in the courtroom. Pete said a group of people had been continuously spreading misinformation to make her look like a bad person. hmm Yeah, a group of people online continuously spreading false information to make her, a Black woman, look like a bad person. Interesting. The people, the people, meaning not unite the people, but the government, on behalf of the people of the state of California, charged Peterson with assault with a semi-automatic firearm on Pete, having a concealed firearm not registered to him in a vehicle, and discharge of a firearm with gross negligence. In count 1, the people allege Peterson personally used a firearm. In counts 1 and 3, the people allege Peterson personally inflicted great bodily injury on Pete. The people also alleged aggravating factors under the California Rules of Court. The case went to trial in December 2022. Among other witnesses, the defense called Sean Kelly. Kelly testified he lived near Nichols Canyon. In July 2020, Kelly was asleep. He was awakened by lots of shouting and voices. He looked through his window and saw 2 girls arguing. Then they started fighting. They were pulling their hair and hitting each other. It was quite violent. A tall man got out of the driver's side of the car and got involved in the fighting. One of the girls went to the car. Kelly then heard what at first he thought were fireworks. He saw a muzzle flash at about the same time. A smaller gentleman got out of the back passenger seat. He was shouting a lot. Kelly saw more flashes and what was obviously gunfire. The muzzle flash was near the girls. Kelly did not hear anyone say dance bitch, although both defense counsel's questions and Kelly's answers were unclear. Kelly seemed to say the girl, who was the aggressor, went to the car and he saw the muzzle flashes coming from her hand. Kelly then said the flashes came from the shorter man. Kelly testified, I believe I saw the girl shoot first. They were both shooting. Kelly never saw a gun. He called 911. On cross examination, Kelly admitted he told investigators that the short guy came out of the car and then he shot the girl. The girl then fell into the road and started bleeding. When asked what was he saying at the time, Kelly replied, a torrent of abuse. It was all just N words. And F mother effer and end quote. End quote. Kelly also admitted he'd never mentioned a girl involved in the shooting to the 911 operator, nor did he mention a female shooter to the responding officer. Peterson chose not to testify. The jury convicted Peterson on all 3 counts and found the firearm and great bodily injury allegations true. Peterson, represented by new counsel, filed a motion for a new trial. The court conducted a lengthy hearing on the motion over several days. The court ultimately denied the motion. The court conducted a bench trial on the factors in aggravation under the California Rules of Court. The court found true aggravating factors: that Peterson used a weapon in the commission of the crime and that the victim was particularly vulnerable. The court also found Peterson's conduct toward the victim after the incident to be an aggravating factor. The court listed social media posts releasing songs with lyrics directed towards the victim, attempts to dissuade or perhaps give money to her and the other witnesses, and violating the protective order. The court stated, I think this is a very significant aggravating factor in this case. The court added there were 2 times that he violated the protective order where the court had to step in and raise his bail. The court found not true the prosecution's allegation that the crime involved a high degree of cruelty, viciousness, or callousness within the meaning of law. The court also found 3 mitigating factors: that Peterson had no prior record or significant record of criminal conduct, that he had actively participated in charitable or philanthropic causes, and that he did not pose a significant risk of reoffending in a violent manner. Before pronouncing sentence, the court heard from 7 witnesses called by Peterson. The court also listed the authors of 76 letters it had received from Peterson's supporters. A prosecutor read aloud a letter written by Pete as a victim impact statement. The prosecution asked the court to sentence Peterson to 13 years in the state prison. The court sentenced Peterson to 10. The court found the aggravating and mitigating circumstances were a wash. The court selected the midterm of 6 years on count 1, assault with a semi-automatic firearm. The court also chose the midterm of 4 years for the firearm enhancement. On count 2, carrying a concealed unregistered firearm in a vehicle, the court sentenced Peterson to the midterm of 2 years to be served concurrently with count 1. The court stayed under section 654, the sentence on count 3, discharge of a firearm with gross negligence. As to both counts 1 and 3, the court dismissed the great bodily injury enhancement under section 1385. The trial court did not abuse its discretion in permitting the prosecutor to ask Pete questions directed to her inconsistent reports to police and her attitude about the case and about testifying. Daystar Peterson contends the trial court abused its discretion in allowing testimony and evidence concerning Megan Pete's emotions about the incident and its aftermath. On direct examination, the prosecutor asked Pete questions about her initial statements to law enforcement and medical personnel that she'd cut her feet on glass. Pete responded that when a woman says a man did something to her, people have a hard time believing you. Pete said she never wanted to come forward. I didn't want to say nothing in the first place. Defense counsel objected to 9 questions along these lines. The court overruled 5 of the objections and sustained 4. On cross-examination, defense counsel repeatedly asked Pete if she had lied. Q. You also on CBS were asked a couple of times if you had some type of sexual relationship with my client, correct? Answer. Yes. Question. And you lied, correct? Answer. Yes. Question. You lied on national TV, correct? Answer. Yes. Question. You also lied to the prosecutors, correct? Answer. Yes. Question. You also lied to Detective Stogner about this issue about the relationship, correct? Answer. Yes. On redirect, the prosecutor asked Pete questions that were follow-ups to areas defense counsel had raised. Pete testified people had been making up things and putting out different stories that weren't true, saying that I had never been shot at all. So Pete continued, I had to come out and say, yes, I was shot. I didn't just step on glass. I should have told the truth initially. I know that now. And I thought I was trying to protect people. I thought I was doing the right thing. I thought I was protecting myself, but in the long run, I wasn't. Relevant evidence is evidence having any tendency in reason to prove or disprove any disputed fact that is of consequence to the determination of the action. Even if evidence is relevant, evidence code gives the trial court discretion to exclude it if its probative value is substantially outweighed by the probability that its admission will create a substantial danger of because we're only on page 12 of 46 and we've been here for an hour 30. So Peterson said that Meg Thee Stallion's testimony was irrelevant and prejudicial because it elicited sympathy for the victim. However, at the outset of the trial, the court instructed the jury, your verdict must be based only on the evidence presented during trial in the court and the law as I provide it to you. The court also told the jury, do not let bias, sympathy, prejudice, or public opinion influence your decision. And before closing arguments, the court again instructed the jurors, you must not let bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. We presume the jury understood and followed the court's instructions in reaching its verdict. The trial court did not abuse its discretion in admitting a photograph of Tory Lanez's torso and arms. Peterson contends the trial court reversibly erred in admitting evidence of Peterson's creative expression, specifically a photograph that showed tattoos on his torso and arms. At trial, Officer Sandra Cabral testified she and her partner stopped a vehicle that matched the description of the vehicle in a radio call they'd received. So when they took them into custody, took them to the police station and did all the testing, they also took photos. They have a photo of Daystar Peterson in black shorts or swim trunks, shirtless, and you can see the tattoos on his chest and arms. This was brought up, apparently, during the trial in a sidebar, and the judge said, he has tattoos. I don't see anything wrong. And they did not ultimately object to them. So if I said they objected, let me restate. In a sidebar, they had a discussion during the trial about these particular photos. At the conclusion of the evidence, the court discussed the exhibits, the photos in question, including photos of Tory Lanez's arms and torso and his tattoos. When the court asked defense counsel if he had any objection to the admission into evidence of those photos, Tory Lanez's lawyer said no. We don't object. So since you didn't object during the trial, you can't retroactively apply your objection now. And then they go through the case law that Tory Lanez lawyers cite in their appeal. The record does not support Tory Lanez's contention that the photos injected racial bias into the proceedings. The prosecution did not offer the photographs of evidence of any alleged gang affiliation. There was no gang allegation in this case, and no one ever suggested that Peterson had any gang ties. The prosecution offered the photos, and the court admitted them into evidence solely to show the identity of the individual officers the identity of the individuals the officers swabbed for gunshot residue at the police station. The record does not reflect whether Peterson was wearing a shirt when police stopped his vehicle. Pete testified they'd just emerged from the swimming pool. She was wearing a bikini, and Harris was in a swimsuit too. Pete's stylist, Eric Culberson, called by the defense, also testified both Pete and Harris were wearing swimsuits when they got into the SUV. Culberson also testified Peterson was wearing drawers when they left Jenner's house. In his closing argument, Peterson's counsel referred to what Peterson was wearing as his trunks. There was no testimony at trial that Peterson had been wearing a shirt, and the officers asked him to remove it in order to swab his hands for gunshot residue or to take his photograph. Presumably, there was also no t-shirt in evidence. So they took the picture of him as he presented. It did not alter his appearance in any way. He is saying that what they basically did was they cited a case that had to do with whether or not a jury being exposed to images of tattoos of a defendant caused undue racial bias with regard to allegations of gang behavior. There are no such allegations in this case. It's completely irrelevant. It's beyond a Hail Mary. It's beyond a Hail Mary. Beyond. No, he did not. He said drawers. I said drawers. You know how much I get accused of just being a square up on here? I was like, if I say drawers, people are going to be like, oh my God. I said drawers because that's what they is. They draws. He was in his drawers. But no, it very clearly, fully spelled out drawers. And that's why they said, oh, you want to retroactively object? You can't do that. And it still wouldn't have worked. Even if they would have said, yes, we do object. Yes, we do object, even just for the purposes of this is going to be something we appeal later. They would have said, yes, we do object. The Court of Appeals still would have said, okay, you objected at the time. That's great. It's still irrelevant. There was nothing no gang talk, no accusations having to do with gangs in this case. Nothing. Nothing. The jury was presented nothing having to do with gangs. Tattoos are not a one-to-one equivalent. Tattoos are not a one-to-one equivalent. Oh, because somebody has tattoos, they must be gang involved. That's a bias and a stereotype. Gang was never mentioned in this case. So no, them seeing photos of his tattoos did not bias them into thinking he's a violent black gang member. He wasn't accused of gang-related crimes. There was no testimony on the record about gang affiliation. They were just tattoos. Yes, that's what they tried. So this comes down to Peterson asserts the prosecution explicitly and improperly introduced racial bias into the proceedings by asking a witness about what appears to be a tattoo of a firearm in the middle of Peterson's chest. Culberson testified he was Pete's stylist and friend. He sometimes was Pete's driver as well. From the questioning, it appears the defense called Culberson to ask him if Pete or Harris had a gun in their luggage. On direct examination, defense counsel also asked Culberson if he'd ever seen Tory with a gun. Culberson responded no. Counsel asked if Peterson ran around with guns. Culberson answered no. On cross-examination, the prosecutor asked Culberson a series of questions about whether he'd ever seen Harris with a gun and whether he'd seen Pete with a gun at any time that day or night. Or if he'd ever seen Pete with a gun at any time in that day or night. He did not ask Culberson if he had ever seen Peterson with a gun. On redirect, defense counsel then asked Culberson if he'd ever seen Peterson with a gun, if he'd ever seen Peterson have a bag that had some weapons with him, and whether he'd ever seen Peterson discuss anything about firearms. Culberson answered no to those questions. On re-cross examination, the prosecutor and Culberson had the following exchange. Question. Now, counsel asked if you'd ever seen Tory talk about guns or if you've ever seen him with guns. Do you recall that? Answer, yes. Question. Do you see the big gun that Tory has tattooed on the center of his chest? Answer, no. I haven't seen Tory's body. Defense counsel did not object to that question. So since you didn't object at the time, you cannot bring it up retroactively in an appeal. The record does not support Peterson's contention that prosecutors utilized Peterson's tattoo, which is intertwined with his rapper persona, to lead jurors to conclude he is a violent criminal with a predisposition to commit crimes. It was defense counsel It was defense counsel who asked, both on direct and on redirect, if Culberson had ever seen Peterson with a gun. Neither of the prosecutors even mentioned Peterson's tattoos, much less the tattoo of a firearm, in their closing arguments. Peterson also complains that Pete's testimony about a music video Peterson had released poisoned the proceedings by directing the jury to infer that if Peterson was chopping up horse legs in a music video, he was violent enough to shoot her. Peterson seems to be referring to Pete's answer to the prosecutor's question about whether she regretted having come forward. Quote, if I would have known that coming out and speaking my truth would come with people agreeing with me being shot, if I would have known, I would have started to lose my confidence, lose my friends, lose myself. I didn't ask for this. I didn't want to come out about it in the first place. I started to feel like, damn, maybe I should be dead. I got to watch Tory drop music videos chopping up horse legs and people laughing at it like that's okay. Defense counsel did not move to strike Pete's reference to the music video. No such music video was offered into evidence or shown to the jury. In any event, Pete's brief reference to the video, which she took as directed at her or even as a threat, was permissible for the same reasons we've already discussed. It's relevant to Pete's attitude about the case or about testifying. Tory Lanez says the jury did not hear his account regarding the night in question because the court ruled that if he testified, prosecutors could introduce his music video and rap lyrics during cross examination. Peterson mischaracterizes the record. The bullshit amount of money that he paid for this bullshit filing. This is a clear example of lawyers just coming up with whatever to file the appeal to satisfy their client that they have filed the appeal. This is some of the flimsiest nonsense ever. When you do things like misstate the trial record, do you think the appeals court isn't going to catch that when literally all they do is go off of what is actually in the court record? You think they're going to take your word for it? No, they're not going to do that. The first thing that's put onto a docket with an appeal is not the appeal document, it's the previous court record. And they spend months going through the official court record of what had actually happened, of what had actually been said to determine their rulings. It's also really just pathetic that this man would suggest that if the jury saw his music video that accompanied his stupid song about Meg, that if they saw that or they read the lyrics, that they would assume he did it. And that would mean more to them than all of the other evidence, like his own admissions in text messages and phone calls that he did it. That was somehow gonna mean more to them is absurd. Well, I think he might have ineffective counsel in here, which is interesting, but we'll see. We'll see. Okay, so Peterson mischaracterizes the record. Midway through the defense case, the prosecutor told the court he was asking to inquire about prior acts of violence if Peterson testified to rebut the character evidence put on by the defense. The court replied, "Well, I think the state of the evidence as it is now, I would not allow that. Of course, I don't know what he would say if he testifies. It may become relevant depending on what he were to say. But at this point, I will exclude that." So the exact opposite happened on the record. This is why you don't listen to people's public statements. They say, well, the judge ruled that if I testified, then all these other things would become evidence. And the judge actually said, no, I would not allow those things. They played him for this ruling. Them lawyers played him and his pocket. I mean, not for this ruling, for this filing. The entire motion to dismiss is a fleecing of Tory Lanez pockets. when it literally is the appeals court going, "Well, that's not what happened. Well, that's not what the judge said." It's crazy. The judge said the prosecution had a list of things that it thought it may want to enter into evidence if Tory Lanez testified. What the judge actually said was, "The best I can tell you at this point is if your client testifies, I'll have to take it on a case-by-case basis. But essentially, anything pertaining to this case obviously is fair game. If it pertains to some other incident, maybe it is, maybe it isn't. It depends." After the defense had called 7 witnesses, the following exchange took place. The court: "So, you've advised me that your client has elected not to testify." Attorney: "That's correct, Your Honor." The court: "So, Mr. Peterson, you know you have the absolute right to testify if you choose. You have the absolute right not to testify if that's your decision. If you testify, you will take the stand and be questioned just like all the other witnesses were by both sides. If you choose not to testify, I will instruct the jury not to consider it or not to hold it against you. Do you understand what I have told you so far?" Daystar: "Yes, Your Honor." The court: "Have you had a chance to discuss the decision with your attorney?" Daystar: "I have, Your Honor." The court: "And based on your discussion, is it your choice at this point not to testify?" Daystar: "I will not testify." Neither Peterson nor his counsel ever told the court that Peterson wished to testify, but was deterred by the prospect of impeachment by the prosecution, meaning the prosecution trying to get additional evidence onto the docket against him, or admitted into evidence, I should say. And then they get into case law. They said that a mention of Daystar Peterson having a criminal case in Florida was prejudicial. The judge says no. There was mention to a 2017 incident. The jury was not permitted to know any details of what that incident actually was. And the both counsel agreed to a special jury instruction because it was a case that resulted in diversion. So both counsel also agreed to a special jury instruction about diversion. So no, this was not an issue. Peterson contends Peterson contends the trial court reversibly erred in permitting the prosecution to play for the jury its recorded interview with Kelsey Harris. So they go through all her nonsense. And when she got on the stand and attempted not to testify, and they used the recording of her of her interview in court. There was an Instagram post that was also admitted into evidence that they say was improper, and the court says it was not. this is another exhibit, this Instagram post that Tory Lanez's lawyers did not object to being admitted at the time. I can't believe they wrote this whole waste of a appeal. The the appeals court also found that if if the Instagram post was admitted, it didn't have any material impact on the outcome of the case. And the determination of the jury did not rest on the Instagram post. This is another the jury was given improper instruction. The appeals court says no. The jury was given all the proper instructions with respect to all of the counts. And this is just a bunch of case law, which is why I'm skipping it. So, here's an example. Here's a very clear example of where I talked about this before with Drake filing his notice to appeal, where I said there are definitely situations where a case goes to appeal and the appeal court will find an error, but they won't overturn the lower court because the error that they discovered was not material to the outcome of the case. So, right here is a concrete example of what that looks like. Okay. So, one of Tory Lanez's points of contention for his appeal was the instruction given to jurors, okay? And the appeals court says, "We review the adequacy of an instruction independently. From the bench note, it appears the trial court should have given the jury." Hold on. Should have given the jury instruction number 252, listing assault with a semi-automatic firearm and the firearm enhancement as requiring only general criminal intent, but listing carrying a concealed firearm within a vehicle as requiring the specific mental state of knowledge. However, on this record, the court's failure to do so was harmless. In reviewing a claim of instructional error, the court must consider whether there is a reasonable likelihood that the trial court's instructions caused the jury to misapply the law in violation of the Constitution. Instructional error requires reversal of the judgment only if it resulted in a miscarriage of justice, meaning it is reasonably probable the defendant would have fared better in the absence of the error. So he would not have been convicted if not for that error. It wasn't that basically the appeals court saying it wasn't that deep. You would not have been found not guilty if this error had not been made. You still would have been found guilty. This error was made, yes. Call it clerical. You're still guilty as defined by the jury. Then there's another jury instruction, and where that Tory Lanez brings up, excuse me, and the appeals court says this was also, if there's any ambiguity about this other jury instruction, it's harmless and didn't have a material impact on the outcome of the jury's decision. He also said that prosecutors engaged in misconduct and made improper comments during closing argument. They say nothing that requires reversal. Peterson's claims of prosecutorial misconduct fail on the merits. A prosecutor's conduct violates the 14th Amendment to the federal Constitution when it infects the trial with such unfairness as to make the conviction a denial of due process. So then they go through case law to back up their conclusion. And then once again, they use Tory Lanez lawyers' actions and words against them in this ruling. None of the prosecutor's statements constituted deceptive or reprehensible methods that were reasonably likely to have affected the outcome of the proceedings. Now there has another claim in here of a conflict with one of his attorneys. And they're like, yeah, no, that doesn't have any material impact either. We're almost done. We're on 41 of 46. Yeah, they are not impressed at all. Peterson's wholesale failure to support any of these assertions with citations to the record is telling. Mm, mm, mm. Then he gets into sentencing was improper. He says he should have been given the lowest possible term. And the appeals court says, no, no, you were right there at 10 years, buddy. There were aggravating factors that justified his sentence. His conduct after the shooting was a major factor as a mitigating and aggravating factor to his sentencing. Peterson challenges that Megan Thee Stallion was a vulnerable victim. And they say no resentencing is necessary in this case. He also, yeah, he did also allege ineffective assistance of counsel, um, or accumulation of errors on their part that basically equates to, and they said no. As we find no ineffective assistance of counsel or prejudicial trial court error, we also find no cumulative error. We affirm Daystar Peterson's conviction. We did it. We got through. The end. The end. The end. The end. End. So all of his things have now been denied. All of his cases are now over with regard to this. His habeas corpus. What is it? Yeah, his habeas motion was previously laughed out of court, and now his appeal, where he was going to win for sure, win this one, get out of jail, blah, 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 blah. I think this might be day 2 of tough titties for the bands, fans, biscuit heads, and hoe cakes out there. Toughest, old, wrinkled titties. Yeah, she could have just in a moving vehicle ducked or run away. No shoes on. She wasn't vulnerable. Yeah, she was. Pathetic, pathetic, pathetic men. God is so pathetic. Look at him. Pathetic. Uh-oh, here comes Princey. I'm so sorry. I'm so sorry. Princey, come here. Come here while I conveniently show off my sweatshirt again. There's some good ones for you. They right up here too. You see the proportion of where they should be? Armpits right here, titties right here. They're not down here. They're right up here, okay? Right up here. Not even an underwire. Just this where they be. Hey babes, come here. Come here. Say hi to the people. I give him some treatsies. Okay. He came in real serious about it. He came in real serious about it. That's why I had to kind of keep him facing this way, because if I would have let him turn this way, he would have just wrapped himself around me and I would have had to leave. I would have had to leave. So yes, Tory Lanez conviction upheld sounds a lot better than appeal denied, because no, the appeal process was not denied to him. He was allowed to go ahead with his little appeal process. He was allowed to do all that. His conviction was upheld. So in terms of, I'm jumping off of that. In terms of to the thing that I'm actually really focused on and thinking about is this Lindsay halitosis thing and what's going to happen with whether or not she was appointed improperly. As I said this morning, the judge said there's portions of the transcript that are missing from the grand jury proceedings in the James Comey case. But the judge who's hearing this, let me back up. Letitia James and James Comey both filed motions to address the illegality of this woman being in the U.S. Attorney's office. Those were combined and sent out of the Virginia district where they're being prosecuted down to, I believe, South Carolina, just to separate out the districts. They had a joint hearing this morning before the judge. That judge said, I demanded through several orders the complete transcripts and anything else having to do with this woman and her presentation, and part of the transcript is missing. Also gave a clear indicator that he does not believe that the government was truthful in some of the statements that they have made to the court, and has said that the ruling about whether or not halitosis was legally appointed or not will come out before Thanksgiving. So I just wanted to put a bow on that, because that's the thing I'm going to be paying attention to damn near every single day. And then while we were sitting here, I got an update on the J. Cole lawsuit. So let me look at that and see what they talk about. This is J. Cole being sued by Cameron for being an arrogant dick. UMG has been served. Their response is due on the 24th. Cole World Incorporated was served. Response due on the 24th. Jermaine Cole, I don't see a return of service for him yet on the docket. So it would appear, at least as I'm looking at this, because a summons was issued for Cole World Inc., Jermaine Cole, and UMG. So Cole World Inc. and UMG, proof of service is on the docket. Don't see one for J. Cole right now. I would imagine when that does come to pass, that Cole World and Jermaine Cole will be represented by the same counsel, I would imagine. Thank you, beautiful. I appreciate you so much. Baby, I'm trying to update my internal filing system so that I don't forget all of these damn cases. The other night I was trying to talk about a Drake thing, and I just got so in my own brain, so turned around, as the words were coming out of my mouth, I was like, I'm confused. I'm not sure I'm talking about the right thing here. I know what I'm talking about, but I don't think I'm applying it to the right case. So yeah, I'm still getting it all together. But yes, J. Cole being sued by Cameron is definitely still in play. Okay. And We await proof that J. Cole has been served, but their as it stands right now, their responses are due. When were they served? Oh, these are coming in kind of late. So this was filed on, let me look here. This was filed on October 28th. Cole World and Universal Music Group were served on the 3rd, November 3rd. So that was 10 days ago. And their answers are due right before Thanksgiving. So I've thought about it. I've thought about it. I've just been really busy with other things. But I thought about it last night, as a matter of fact. I can't remember why, but when I was laying in bed, I was thinking to myself, I might need to put something here or put something here that I can visually just have as a cheat sheet for myself of what is what? You know what I mean? I always kind of giggle at those people that have like whiteboards, you know? They're one of those like whiteboard content creators. I'm like, oh baby, good for them. Could never be me. Might be soon. Might be soon. As soon as we got to the Barry White trust situation splitting into 2 cases, I was like, oh, it really started for me right there. It really started for me right there. But Drake's name just comes up in too much, you know. So he definitely, I might need to make a visual thing that I can look at and update and just know where things are at, because his name, whether he's a party or not, is central to several pieces of litigation happening right now. So it all gets jumbled in my head for sure, for sure. Cole is pretty simple. He's being sued for being a dick. Not being a man of his word. Didn't nobody teach him word is bond? No, they didn't teach him that. Nah. You only learn that from working class folk or black people. You don't learn word is bond from your white mama, who basically fine and then remarried and is doing even better. She don't teach you word is bond. She don't know nothing about that shit. So, since his mama didn't raise him right, because she wasn't equipped to, I said it. I said it with my whole chest. I said it. Titties up here. I said it. West Coast savior. I said it. Cameron said, let me run you this lesson real quick. You're doing really well. Let's see. We got J. Cole, the 2 Rodney O cases, Meg versus Milagro, Milagro's other case. Oh God, that's right. I forgot about that. Yes, Milagro's other case, the Comey-ish. Yeah, we got that. And then 3 Drake cases, 2 Stake, 1 Spotify. You're doing great. 1 Spotify, which he's not a party of. You're very good at this. Let me see. What else am I? I mean, I'm following a lot more dockets than that, but yes, that's a good summary. That's one of them, isn't it? Yeah, RBX is the Spotify. That's the one he was talking about. RBX is the Spotify case. Good to see you, beautiful. This perfectly encapsulates J. Cole. Stay in, stay out. Fuck YNs. I love YNs. I'm gonna give you that verse. I ain't gonna give you nothing. Just committed to riding that bike. Yeah, he is. Yeah, he is. Ooh, baby, this has been just ice cream on top of a really good pie. You know, I was thinking about this last night. I said, self, because I said it right here on this channel. When this all started to pop off, I said, this is not going to become a thing. I said, this is not going to become a thing. They don't care that much. It's not going to become a thing. And then it became pretty evident. And I came back to y'all and I said, well, it would appear that this has become a problem for the president and his administration. And oh, Nelly, here we are 2 months later. And oh my God. You know, one of the things that I thought was really interesting is, well, all of it is really interesting, right? All of it is really interesting. But the the damning nature of these emails that are coming out. First there was 3, now there's 20,000. Are just, I would say they're breathtaking, but they're kind of a breath of fresh air. And I don't mean their contents, because their contents are disgusting. Their existence, their airing of, the watching people's reaction to them, the how quickly the script flipped yesterday, um with, you know, the House voting on the budget, with homegirl from Arizona getting sworn in. It's like she got sworn into the House of Representatives, and then once her swearing in was over, she turned over here and signed the shit to force a vote on releasing the Epstein files. It was literally that fast. I'm sworn in. Cool. Where's the paperwork? Add my signature. What I find shocking is that Mike Johnson actually scheduled that vote for next month. Or next week, excuse me. Excuse me. Mike Johnson actually scheduled that vote for next week and not next month, which just shows me that Mike Johnson is looking out for Mike Johnson. He wants plausible deniability. You know? It's more beneficial to Mike Johnson if it passes than if it doesn't pass. And in a month, there's likely going to be another Republican in Congress who will then again even out the spread. And votes won't pass, shit won't get released, et cetera, et cetera. So the fact that he said, nah, let's go ahead and do it next week. I said, oh, Mike Johnson's looking out for Mike Johnson, even though he's out there saying this is a Democratic distraction and it's a Democratic hoax and all of that. You could have waited a month. You could have scheduled this in a month when everybody assumes Republicans will have more power. But you said, no, we're going to do it a week after Democrats have more power. That man is, Mike Johnson is a wicked strategist. He does play 3D chess. Even though people think he's a lapdog and this, that, or the other, if you pay real close attention to Mike Johnson, that dude is playing 3D chess. For sure. For sure. So we'll see what happens. But I'm just like, I'm really glad that this has become a thing. The thing. And I don't care, just as, you know, I said, I feel like a lot of these men around the Emaru situation are just getting online to perform solidarity with women, to perform, you know, demands for accountability, even though they really are some red pill bitch ass mofos who are also contributing to, you know, the violence of misogyny online. I think a lot of people are doing that around this Epstein situation in DC as well. They're just performing because it's beneficial to them, but it's beneficial to all of us too. So perform away. Is how I feel. Perform away. that vote is probably going to pass next week because it's just an increase. All of the Democrats are going to vote for it. Fuck the Gang 8. All of the Democrats are going to vote for it. And Republicans, every single minute of the day, are like, I'm probably going to vote for it. I'm probably going to vote for it. I'm probably going to vote for it. I'm probably going to vote for it because they are being inundated by their constituencies online, at their offices, over email every single day. And they want that to stop. So as much as they perform, the Democrats are just trying to distract, and it's not that serious. And Bill Clinton did it too. They all know it's more beneficial for them strategically for these files to come out than for them not to come out. It gives them leverage and power over a sycophant, psychotic president. And it gives them plausible deniability. It gives them an excuse to flip their script on MAGA. It is an opportunity for so many things for Republicans. Yeah, so I'm excited. I think it's fantastic. Fantastic. There were several times I wanted to run online yesterday like, "Y'all, did you see?" But I couldn't. So um what do I think will happen? Um I think that we've got a neighbor who is always sending their child. This happens every collection day. They're always sending their child outside with either garbage or recycling to put in other people's bins. Hey, beautiful. Good to see you. Thank you. Okay, but let me get back to the question. What do I think is going to happen? Um, so far, the neighbors that they do it to are all nice people. But if she took that bag one property over and they catch her doing that, those people are vicious, mean people. And this is since I moved my desk up here and now have this view, I see this now more often than not. But anyway, I'm sorry. I got distracted. You should not send your baby out to do that. um I think one of the things that Republicans have been talking about with regard to this situation. Sorry, my throat is dry. So there's a couple things that come to mind for me. Number one, as I have been saying and have been saying for a very long time, well, for longer than most people anyway, one of the things that Donald really wants to accomplish before the end of this year is that he wants Barack Obama and John Brennan indicted on conspiracy charges. And I told you all a couple days ago that this effort seems to be coming out of one of the federal districts in Florida. Last night, there was confirmation reporting that they're serving a myriad of subpoenas on various parties for evidence. The more information that becomes available in the public eye about Donald and Jeffrey, the more he is going to push for Barack Obama to be indicted, because he thinks he can perform an emotional swapsies with his base. He thinks that if he indicts James Comey, if he indicts Hillary Clinton, if he indicts Barack Obama, that will be an emotional swapsies for them. And they no longer need the Epstein files, right? Because let's not forget that the entire Epstein file thing started because of Donald Trump. Donald Trump said that the Clintons had him killed in prison to cover up their relationship with him. So he started it, right? And that narrative has totally blown to bits. And now everybody is looking at him sideways. But nevertheless, he feels like he can perform an emotional swapsies to satisfy his base. And he is like Necole Key. You can't convince him that he's wrong. And so even though he tried it before and it didn't work, he's going to try it again because he feels like either Clinton or Obama is the main prize, and then people will let it go. They're not going to let it go. So the more information that comes out, the more pressing an Obama et al. Indictment becomes. So what do I think is going to happen? I think Obama is going to be indicted. Not because he was a part of some conspiracy, but because Donald is trying to distract from more and more information coming out about him and Jeffrey. I think that the Republicans are trying to figure out the Republicans, and I don't mean like the GOP overall, as in every single elected person that you see. I mean the power brokers of the Republican Party are trying to figure out, they know that there's a dead end for Donald. They know that. And this is why I say Mike Johnson's strategy is next level if you pay attention to what he does. The Republicans know that Donald has a dead end, and they're trying to figure out with the people and in his position, and they're trying to figure out where it is so that they can make sure they're not strapped to him at the point he falls off the dead end cliff, because he's got no road left. They can still accomplish the majority of the things. First of all, they already have, but they can still accomplish a majority of the things that they want to accomplish as a party without him. And so it would not surprise me if an attempted or actual indictment of Obama or Clinton or Brennan, but Brennan on his own isn't going to matter. He wants Obama or Clinton. So an attempted or an actual indictment is going to meet at the crossroads with a critical dump of information, the files or emails or whatever, and his road is going to run out. The people are going to be outraged at an indictment of a former sitting president for political purposes. The people are going to be outraged about that. That'll be the end of the road for him. The Republicans will be scared of that because it crosses a precedent that hasn't happened before in this way. So that will be terrifying for them, and they'll want to back away from that. And then the moniker that is going to be attached to the president of the United States forever, and I'm referring to Donald, is that he is a pedophile. So that is just a long way of saying, and I know there are a lot of people who are like, "Nuh-uh, this will never happen." And this is my for funsies opinion, okay? I think the Republicans might wind up impeaching Donald because he is becoming a massive, massive liability to them. Fuck democracy, fuck all of that stuff, but to them, he's becoming a massive, massive liability. And they're just looking for the opportune time, and that will be it. That will be it. So, we'll see. But he's not going to stop doing what he's doing. He has to be stopped. He's not gonna be stopped by the Department of Justice because they're the ones aiding and abetting his bullshit. The only ones that can stop him is Congress. The minute he becomes too much of a liability for them, it's over. And going after a former president because you don't like him and because he's still more popular than you, and also he's black, and coming up with fraudulent evidence for an indictment, which I told you all about months ago, and then being branded a pedophile. They'll cut bait. I mean, this is why you can't just focus on, you know, um, what they say at the podium, you know? All day, Mike Johnson said, "This shit is a distraction. This is a Democratic hoax to" he completely parroted every single thing the president said. But what did he do? He scheduled the vote for a time when the Democrats will have an advantage to pass it. He could have waited 1 month to when the Republicans have the advantage to block it. He knows that. He knows that. He knows the difference in November and December. He knows. He scheduled it anyway. So I don't give a fuck what he's saying publicly. For me, that I read that as a CYA move and a hedge your bets move by Mike Johnson. And I'm sure Donald is fucking livid. I'm sure he's fucking livid. You know, you've got the Supreme Court potentially about to rule against him on tariffs. That's $3 trillion. And then he just made people's lives a living hell for the past 11 months, but particularly in the past 90 days. He's made Americans' lives hell. If Republicans can't come up with a healthcare package in 2 months so that Americans have affordable healthcare in January, that's gonna be another thing. So, as far as I'm concerned, the dominoes are falling. Am I putting my hopes on? Am I holding out hope for? No, no, no. Will I be surprised if they don't impeach him? Fuck no. I will not be surprised at all. But nevertheless, I could see a very clear pathway to them doing that because it's strategically advantageous for them to do so. And for no other reason. But It's strategically advantageous to do so. They're going to be here long after he's gone. They are going to be the ones that are left with whatever's left, not him. He ain't gonna be here. And once you stand up to the guy and tell him to go fuck himself, that is kind of half the battle with Donald. It's kind of half the battle. It's just calling a spade a spade. Hello, beautiful. Yeah, absolutely. And they do that all the time, right? Mike Johnson does that all the time. There are some, for the whole part, I'm like, FTD. I can't stand Mike Johnson. I can't stand him. I think he's a danger to the country just in his own right. But nevertheless, that dude is a power broker. He has positional power, and on a consistent basis, he will do something that is not beneficial to Donald, but is beneficial to the longevity of the Republican Party. So I get you. I get you. Hard wink, wink. Yeah. Yeah. They do. They definitely know that he's a ticking time bomb. And when you look at what it is that he has been able to accomplish, I still stand by this, and I know it's a controversial way of putting it, but I think it's the most effective way to say it. Donald Trump is the most effective president in the history of the United States of America. Because effective equates to implementing your agenda. And he is the most successful president to ever do that, ever. So when you look at what he's done in 11 months, it is unfathomable to me that we could go another 3 years with this. Completely unfathomable. How? What's going to be left? I don't want to know. I don't want to know what comes after. All of the destruction that has been wrought so far. The other thing that I was thinking to myself the other day, because he did an interview on Fox talking about H-1B1 visas and US talent and all of that stuff, with Laura Ingraham over on Fox News, and I only watched a snippet of it because it was on social media, and I didn't bother to go get the transcript because I've got more important things to do with my time, but the snippet was enough. I actually watched it several times, and obviously this could just be a style choice of verbal expression, but Laura Ingraham was giving him pushback on, you know, we have perfectly skilled workers here in the United States of America. We don't need to be bringing in foreigners to take our jobs when we're perfectly skilled. And he said, no, you don't. And I realized it was just one of those like, oh, light bulb moments of a realization of realizing that Donald talks about America as if he isn't one. he says things like when she says he doesn't say "we" very often when he's talking about America. He talks about it as if he's not a part of it, and that, for whatever reason, smacked me in the face in watching that snippet of him talk to Laura Ingraham when she was saying, "Well, we have this," and he was like, "No, you don't. You don't have this, your people don't have this. America lacks this, that, and the other. America is a country that does not have it." I thought to myself, he's talking about America like he is separate from it, above it, better than it, the judge of it kind of tone. I think America is just another piece on his little board of play, his little monopoly board. It's just the mechanism, it's just the corporation that he uses to do the things that he wants to do. But he will definitely fall into talking about America like he is a leader of a foreign country. I just thought that was interesting. Yeah, it was giving all nothing but dictator, nothing but I am the alpha and omega here to rule here to rule you, here to judge you. It was just really interesting. Really, really interesting and unsurprising, right? It's just affirmative of, well, of course he thinks he's separate and above and the judge and jury of, and that he literally looks down from his, his self-proclaimed position in the situation. He is above America. America is beneath him. He looks down on it and all of us. Not surprising in the least. Want to give a shout out to Darling Miss Darling for the $10 contribution. Shout out to Demetrius for the $5 contribution. Thank you for the tithes. Miss C60 or Mrs. C60, hello, beautiful. Thank you for the support. I appreciate you. T-Mac, thank you. Old School Gemini coming in as a real one. Appreciate you. And Nate again, late gang. Gang, gang. Thank you. Yeah. Well, the law ain't going to work on anybody because he's put a corrupt figurehead in charge of the laws. Two corrupt figureheads, several corrupt figureheads as the head of the laws. So the laws ain't going to do shit to anybody who should be held account at the federal level at this point in time. And we'll see. We'll just see what happens. But if I think that he is in probably the most precarious position he's been in a very long time. And I include being, convicted of 34 felonies. I include being investigated for trying to steal an election. I include all of that. This is the most precarious position that Donald has ever been in. And He can't win. There is no emotional swapsies that he can perform for his base or for the media that is going to make them forget and stop demanding the Epstein files. Nothing. And so the more extreme he gets, the more extreme of a response he's going to get met with. And that can't go on forever. People are already fed up. They're already living in a pressure cooker, in a vice grip of bureaucratic dysfunction because he has broken the government and is hell-bent on taking everything that he can away from people. So, yeah, it may all hit that critical stage for him, or it may not. Or it may not. I'm at this point in time just content in observing how it all plays out and in keeping myself, up to date and abreast of the most important details and facts to come through all of these updates that we've been getting. Yeah. Yeah, we still gonna have 1,000 problems, right? We still gonna have 1,000 problems. Hello, beautiful. It's good to see you. Thank you for the support. Yeah. So let me just go ahead and check, make sure we don't have any other damn docket out there. Everything else is federal. I do have a bunch of docket updates, but everything else is federal. Nothing else on the shout out to Tia White, Demetrius, Nidra, and Baby Girl for your support. And I feel like I also saw something from Robin Silver. So thank you for that as well. Yeah, guys. I think that's about it. I think that is about it. I'm not sure. I'm just scrolling over some things. I don't see anything. Oh, thank you, beautiful. Thank you. Oh, yeah. Sean Combs has been given some additional time. Sean Combs has been being a bad boy. No pun intended. I just heard myself. No pun intended. He's been a bad boy. Yeah, he's been doing all kinds of things he's not supposed to be doing, including drinking. And he has, what did he do? He had a three-way call that he wasn't supposed to have, and he was like, "Man, I was talking to my family. It's whatever." And he's been drinking prison toilet made liquor. Yeah, and they just add on to your sentence. And so he's got another month added on to his sentence, I believe. It was somewhere between 4 and 6 weeks, I believe, for all of that. And that's pretty much how it goes every time you fuck up in prison, they just add on more time. So, while he awaits, the process and outcome of his appeal, which is on a speedy track, by the way, yeah, he's been handed more time, so Oh, yeah. Yeah, more often than not, when you are fucking up in prison, they just administratively add time to your sentence. You don't necessarily need to be charged and convicted with another crime. Just you broke the rule, and the consequence for that is this. So, who's surprised? Nobody. I've heard all of the rumors and talk about um there's going to be a pardon, or his sentence is going to be commuted after the first of the year. At this point, I don't really care. I'm not going to put my energy into that now. We've got enough things that are actively happening to follow and pay attention to. And honestly, it's fuck him forever. So I don't care if he's in prison or out of prison. It's fuck him forever. And I think that, the people who were convicted of participating in January 6th and did not accept a pardon will always have more respect for me than Sean Combs will ever have or has ever had for me, ever. Because they said, I did that shit. I'm not going to take a pardon because I know that I did it, and I'll just live with that. Thanks. So he wants to pay for a pardon or get on his knees for a pardon or wear the red hat for a pardon. I don't care. Let it be a scarlet letter on his name forever, next to all the other scarlet letters he's got, till the day he dies. Fuck Sean Combs. That's how I feel. That's how I feel. Yeah, there were people convicted of January 6th who turned the pardon down. Yeah. And I will respect those people more forever than I will ever respect Sean Combs or anybody who takes a pardon from this administration. No way. There was like 2 to 4 people ultimately that turned down the pardon, and yep, one of them was an older lady who was like, "Nah, I d," and all of them said the same thing. This pardon is wrong. We all did it. We all did it. I know what I did and how I broke the law, and I've taken full accountability for that, and I'm not going to lie and rewrite the record on what it is that we all did, including me, 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 me. But those were people who were really focused on actual accountability for their actions. Actual accountability and saying, "I know what I did. I didn't know it at the time, or I didn't believe it at the time, but I know that what I did was against the law. I know that what I did was wrong. I know that it was that I endangered people's lives by being there, by participating in this, and I should have never done it, but I did. I did my time, or I paid or am paying my fines or whatever, but I'm not taking a pardon." That's integrity. That's integrity. A whole scarlet alphabet. Yes. Yes. Several people died as a result of January 6th. Also, the people who did accept pardons, they keep finding their way back into jail for doing something, threatening a lawmaker, criminal threats, bodily harm, felony, threatening a former president, showing up outside his house and whatnot. There's that. Essaying women, beaten women, they keep finding their way right back into jail or prison. You know why? Because that's who they are. Shitty people. They were doing shitty shit before the insurrection, and they've been doing shitty shit since the insurrection. Some of them been shot to death by police because they talk crazy to the police while they're committing a crime, or they go at the police all crazy and frantic and shit, and they get shot to death. It's criminals committing crime. Why I never. Why I never. Well, he was shot to death. What you want me to say? Shoot, I hate when people come on with he was pew pew together. Baby, you lucky Betty ain't in here. I'd be like, he was shot to death. But then one of them bald head bands would report my channel. So I guess Betty can stay tucked away. She got her own little pillow and blanket on the bed. She sleep with me at night. I ain't even bothered to get her up today, you know? It's a rainy, cold day. She tired. She need to get her good sleep. They really should. They really should. They won't, but they should. All right, y'all. Well, I mean, this was interesting. Let me just do one quick round the way. Uh, Some psycho rushed Ariana Grande. The wicked red carpet. Somewhere in Asia. And Cynthia Erivo almost whooped his ass. That was great. But yeah, no, other than that, that's about it, y'all. Yeah. She really do. She be all up on that pillow, just laying there all shiny, all pretty like. Yeah. Hmm. Yeah, he about to get publicly caned. That's what's gonna happen to him. That was stupid. Stupid. I don't know why you would do something like that in a country where they take you to the town square, put you on a platform in front of everybody, take out a metal stick, and then beat you with it. And don't embarrass the country. They gonna add some lashings to your overall numbers. I did not create the word twat waffle. I've definitely heard twat waffle elsewhere, but I did bring it here. It's an import, it's an import. I wish I could take credit for twat waffle. I can't even take credit for biscuit head or hoe cake. I checked. Biscuit head has an etymology that pre-existent to this channel. A whole bakery, a whole cookbook. We got a whole bunch of things going on. Y'all are the best. I'ma go. because I got things I gotta go do, just like, you got things you gotta go do, even though we don't wanna do them. We're gonna go do them so we can end the week strong, you know? Yeah. Um, if something substantial pops off, baby, I'll be back. But if not, I will see you soon. Thank you all for hanging out, staying in the know on all the things. I hope you continue to have a good day. If I don't see you again this week, have a wonderful weekend. I have a feeling I'll see you at some point. Let it be all for the good things, or for the things that we can celebrate and cackle in. um, and I will see you all very soon. Take care. Peace.